If you're watching this video, you may have recently hired a lawyer, or you may be considering hiring a lawyer. In this video, we'll be looking at everything that you need to know to save money and get the most out of hiring a lawyer. At the end, I'll tell you how you can download my template for getting all of your information together in one place so that you can give your lawyer everything that they need to do a great job for you. Keep watching. This is the roadmap of everything that we'll be looking at in this video. The 5 rules for getting the most out of hiring a lawyer are: Rule number 1, be organized. Rule number 2, be nice. Rule number 3, be dependable. Rule number 4, be reasonable. Rule number 5, be respectful. Before I begin, please keep in mind that I'm not giving any legal advice in this video and that watching it does not create a lawyer-client relationship. If you think that you'd like to ask a question that's specific to you and your situation, please comment below and I'll do my best to respond promptly. Rule number 1, be organized. If you're hiring a lawyer, you'll likely need to provide them with information and documentation. For example, if you're hiring a lawyer to start a lawsuit for you, you'll need to provide all kinds of information about the parties, events, and relevant issues. You'll also need to provide whatever documentation you have which relates to the lawsuit. To make it as easy as possible for your lawyer to understand the situation, find information and fill in the blanks with whatever information may be outstanding, it's best for you to be organized and provide information to your lawyer in a simple, easy-to-use way. In my practice, I've had many clients hire me and bring me a shoebox of loose documents to our initial meeting. None of the documents were organized, nothing was scanned, and nothing was written down. In these situations, the first meeting is never as effective as it could be because I need to spend my time helping my client organize their thoughts and sort through their documents. Alternately, I've had other initial client meetings that have been much more effective because clients have come with their documents and information organized. To get the most out of an initial meeting with a lawyer, I recommend that you do the following. Instead of bringing disorganized documents in a shoebox, organize your documents by date and put them in a 3-ring binder. Use sheet protectors for documents that are originals, which you shouldn't be hole punching, such as original contracts, certificates, and other sensitive documents. If your documents can be organized by type, insert tabs into the binder to organize them in this way. Also, to save the time of your lawyer or your lawyer's assistant, scan your documents ahead of time, saving them as PDFs, and provide them on a USB flash drive. Name each document using a year, month, day convention that will keep the documents in order. For example, for something like a medical requisition form dated June 6, 2022, name the file 2022-06-06 medical requisition.pdf. With respect to information about the parties, timelines, and issues, write this information in an electronic document and provide it to your lawyer. At the end of this video, I'll tell you how you can download my template for keeping all of your information in one place. If you're not sure exactly what you should and shouldn't include, use your best judgment. Your lawyer will naturally ask you additional questions and may request more documents that you haven't included. But by doing your best to provide as much information up front, you can help your lawyer get a leg up on your file. If you've ever seen the movie Jerry Maguire, you may have heard the expression, "help me, help you." You should keep this expression in mind when you're hiring a lawyer. By making things as easy as possible for your lawyer and their staff, you can make it easier for them to find relevant information, identify missing pieces, save time, and work on your file more effectively. Rule number 2, be nice. This rule should be an obvious one, but I can't tell you how many times I've had clients who have been rude to me and my staff. And even though I'm bound by a professional code of ethics and I strive to do a great job for all of my clients, I understandably don't enjoy working for rude clients as much as I enjoy working for nice ones. There's an expression in business that people generally like to work with people that they know, like, and trust. If you're hiring a lawyer who you've never met before, they may not necessarily know or trust you, but at least they can like you if you're polite and easy to work with. As much as possible, I recommend that you also be nice when talking with your lawyer about other people. If you're hiring a lawyer because you're seeking a divorce, don't badmouth your spouse or their lawyer. If you have information to share with your lawyer about your spouse doing bad things, that may be legally relevant and be something that your lawyer wants to know about. However, simply calling your spouse names or complaining about how you don't like them or their lawyer only wastes time and makes you look bad. Even in the most populous cities, legal communities can be tight-knit, and badmouthing one lawyer to another can be a bad idea. The lawyers may have a good professional relationship, or may even be friends. Unless you have information suggesting that a lawyer has actually done something wrong, there's no point in insulting another lawyer and complaining about them. As with badmouthing another party, it's a waste of time and can only put you in a bad light. On the other end of the spectrum, if you're happy with your lawyer, if you'd like to work with them again in the future, and if you want to give them a token of appreciation, you may wish to give them a small gift. Over the years, I've had many clients give me all kinds of gifts, including thank you cards, bottles of wine, and homemade baked goods. Whenever I receive such a gift, I always give it to my staff so that everyone can share in the generosity. The gifts generally improve the relationship between me and those clients. It makes me and my staff want to go the extra mile and work even harder for them. In your case, a small gift may mean that your lawyer will work on your file ahead of another file, and it may get you hundreds of dollars of extra effort that the lawyer may do on your file on a complimentary basis. If you're not comfortable giving gifts or it's not in your budget, don't worry about it. It's not the norm and it's not something that's expected. However, at very least, be polite to your lawyer and their staff. Rule number 3. Be dependable. If you're hiring a lawyer to help you with something, you need to be dependable. You need to be the kind of client who's prompt, shows up for meetings on or ahead of time, and is available at critical moments. For example, if you're hiring a lawyer to help you buy a home, be sure that they have all of the information that they need as soon as possible, either from you or your realtor, so that the lawyer can open your file and start working on it. If your lawyer asks that you meet with them to sign documents, be at their office on time or ahead of time. If a slot opens up in your lawyer's schedule, you may be able to get in sooner, and if any issues come up, the extra time may be useful to ensure that everything gets taken care of during the meeting. On the day that the deal is going through, time is of the essence, so be available by phone, email, or both, in case there are any hiccups and your lawyer needs to contact you. Using another example, if your lawyer is helping you defend a lawsuit and you need to appear in court, be in time and be dressed appropriately. If you drive to the courthouse, be sure to go ahead of time so that you can get a parking spot, put enough money in the meter, and figure out which room you'll be in. If you're going to be called to give testimony, know your case, be ready to provide short answers, and speak as respectfully as possible. More generally, being dependable also means behaving in a way that doesn't exhibit red flags. If a lawyer picks up on too many warning signals and thinks that you're a liability, they may not want to work with you. They may be afraid that working with you may cause them to suffer negative consequences, and that you'll do things like fail to pay your legal bills, waste their time or their staff's time, disrupt or attempt to disrupt work being done for other clients, report or threaten to report them or sue them or their staff, or cause general anxiety and make it a headache to work with you. To make your lawyer as comfortable as possible and to make it easy for them to do their job, I recommend that you do the following. Don't be cagey, evasive, or secretive. When hiring a lawyer, some people won't answer straightforward questions, are unwilling to provide information, or leave out important pieces of information, such as their name, contact information, and names of opposing parties. Lawyers need this information and need to run conflict checks on the names of any and all parties who are involved to be sure that working for you wouldn't put them in an ethical conflict. Lawyers are subject to duties of loyalty, and if they already represent somebody and you're opposed to that person, they can't represent you. In general, many lawyers aren't willing to engage with people who fail to provide basic information. Don't be impatient. Some people want lawyers to begin work immediately, without first meeting with them or providing a retainer. Most lawyers won't work for a person without first meeting them, because they're subject to rules which require them to identify clients before undertaking work. Don't be desperate. Some people contact lawyers in a state of despair, which may be accompanied by rash or extreme behavior. While this may be understandable in certain situations, like if a person has been arrested or if someone has passed away, in most other situations there's no need to appear desperate, and it may only cast you in a negative light and make you seem like a difficult client. Don't be too much of a self-helper. Although it's very much appreciated when clients provide information and documents in an easy-to-use way, as I described in Rule 1, some people go too far and try to do too much of their own legal work, and then they contact a lawyer only after they've encountered difficulties or made mistakes. Fixing the mistakes is often more costly than if the person had simply come to a lawyer in the first place without doing any work. Finally, avoid typos and problems with grammar. Typos happen, and most lawyers don't expect their clients to be masters of the written word. However, as much as possible, try to write in a way that's free of spelling and grammar issues. Poor spelling and grammar can be annoying, but even worse, it sometimes makes it impossible to understand what a person is trying to communicate and wastes the time of the person trying to decipher it. In the world of law, it's very important to have firm understandings of what people are saying. To make things as easy as possible for your lawyer and to make things run smoothly, try to be as dependable and easy to work with as possible. Rule number 4, be reasonable. Reasonableness is a standard commonly used by lawyers, judges, and other decision makers. Over the past few decades or so, many high-profile cases which have been in the media have caused some people to wrongly think that the law routinely delivers unrealistic results. For example, many people think of the famous case involving a person who was burned by a hot beverage from a fast food chain and believe that the case means that they can get millions of dollars for a similar injury. In most cases, it doesn't work this way. Legal remedies and restitution laws vary from jurisdiction to jurisdiction. But in general, the goal of the law is to put a person in the position that they were in before the damage occurred, as much as can be done with money. For example, If someone were to rear-end you in your car, cause you to break your arm, and miss a month of work, it may be reasonable to expect to be compensated for the cost to repair your car, the wages you missed from not working, and the pain and suffering that you've endured. You may even be able to get punitive damages if the person was driving negligently or recklessly. However, generally speaking, in the world of motor vehicle collisions, a broken arm is a relatively minor injury. And if you think that you're going to get millions of dollars, you may need to think again. If you're not sure what is and is not reasonable in any given situation, that's understandable, and your lawyer can help you understand where the goalposts are and what outcomes are and are not likely. However, even before speaking with a lawyer, temper your expectations and set reasonable ones so that you won't be disappointed or surprised if it seems that you can't get as much money as you were hoping for. Along with steering clear of unreasonable expectations, you should also avoid insisting on answers to questions that may be unreasonable depending on the circumstances. For example, if you're having a consultation with a lawyer to explore whether you may have a legal claim and have grounds to start a lawsuit, it may be unreasonable to ask how long it would take to complete the work, if an all-in cost can be provided at the start, if the lawyer can do the work for less than someone else, if the lawyer will do the work for less than their usual rate, if success can be guaranteed, and what the likely result will be. For many of these questions, the lawyer may respond with the rhetorical question, how long is a piece of string? Which means in essence that the question can't be answered because there are too many variables and too much uncertainty. Even for seemingly simple cases, it's often impossible to estimate how long a lawsuit will take, how much it will cost, and what the result will be. Further, success can never be guaranteed, and it's in poor taste to ask a lawyer if they'll price match a competitor or work for less than their typical rate. On the subject of legal fees, you should also be reasonable in your expectation of what your lawyer will be charging you and when you'll be receiving bills. This is information that you should be getting directly from your lawyer. No matter what kind of work your lawyer is helping you with, you should always insist that you be provided with a retainer agreement which lays out important information such as what work will be included, what work will not be included, how much the work may cost all in, if it can be reasonably estimated, when you will receive bills, whether you need to provide a retainer, and if so, how much, what you will be responsible for doing, and what the process may look like in general. Although retainer agreements may be drafted in a way that protects the lawyer's interests, it should also contain many provisions that are designed to protect and inform you as well. If you receive a retainer agreement from your lawyer but you don't fully understand it, or you'd like a second opinion, you can always contact a lawyer such as myself to help you understand it and provide an impartial second opinion. In general, you should expect to pay a reasonable retainer. In my career, I've encountered many people who have either refused to pay a retainer or have said that they'd be happy to provide one, but never did. In general, lawyers are good at detecting people who are trying to get something for free, and these relationships usually don't last long. As much as possible, you should pay your bills promptly and avoid being difficult about them unless you think that there's something wrong with the charges. If need be, you can take it up with your lawyer directly, or you may wish to get a second opinion from another lawyer and avoid potentially souring the relationship. If you have any concerns, your best option may be to get a second opinion from a lawyer like me on whether everything seems to be on the up and up. Assuming that everything's fine, I recommend that you do the following. Follow reasonable advice and give reasonable instructions. Depending on the kind of work your lawyer is doing for you, they may at times present you with different options and opinions on what you should do. Returning to the example of the rear-end collision that I used earlier, if the defendant offers your lawyer $100,000 to settle the claim, your lawyer may suggest to you that you take one of the following actions. A. Accept the offer. B. Reject the offer and make a counteroffer. C. Reject the offer and make no counteroffer. D. Do nothing and let the offer expire. If we were to assume that your arm healed quickly, that you missed only a week of work, and that it cost only a few $1,000s to fix your car, an offer of $100,000 may be quite favorable, and your lawyer may explain to you why you should accept the offer and how it may be a good amount of compensation that is safer than if you were to proceed to court. If you were to instead tell your lawyer that you want to go with option B and make a counteroffer just because you thought that you could get a few thousand more dollars, your lawyer may disagree and warn you that making a counteroffer could risk losing the initial offer. In this situation, it may be unreasonable to not follow the lawyer's advice and fail to go with option A. Although there's no single definition of what it means to be reasonable, you should always be striving for the standard to get the most out of working with a lawyer. Rule number 5, be respectful. To get the best results from your lawyer, respect their time, space, and expertise. Unless you have reason to believe that they aren't doing a good job and that they aren't working diligently on your file, it can be counterproductive to continually request updates, be a backseat driver, and repeatedly ask, "Are we there yet? Are we there yet?" The more time that your lawyer needs to spend responding to your requests for an update, the less time they have to work on your file. Even worse, you may get labeled as a difficult client, and people at the firm may be less motivated to work on your file. particularly if they can work on files for clients who are easier to work with. In general, lawyers are adept at keeping schedules, navigating timelines, and managing work on many different files at the same time. We use calendars and reminder systems to ensure that we aren't missing deadlines and other important dates. To be as effective as possible, we typically let clients know when we have updates, because we know that our clients want to be kept in the loop, and because it also provides us with an opportunity to show our value. It's a relatively efficient, don't call us, we'll call you kind of approach that typically works well. And of course, this doesn't apply if something new comes up and you need to share it with your lawyer. Also, as I mentioned, if you have reason to believe that your lawyer isn't on top of things and isn't doing a good job, this may not apply. If this is the case and you really distrust your lawyer and think that you need to ride them to ensure that they do their job properly, you should probably find a new lawyer. If you want a second opinion about your lawyer, you may wish to contact a lawyer like me for another look. In general, once you hire a lawyer to work on your behalf, you should step back and let them do their thing. If you need to call or send an email, try to do so within business hours. If you have your lawyer's cell phone number, don't abuse it by calling or texting too much. Unless it's an emergency, you should communicate with your lawyer only by email, phone, or letter. You should also avoid communicating with your lawyer using more personal forms of communication, like social media. If you're communicating instructions to your lawyer, it should be through phone, letter, or email. Unless your lawyer has asked, don't send mass amounts of information, documents, or both. Also, don't drop in or show up at your lawyer's office without an appointment. If you show up unexpectedly and unannounced, this may cause conflicts with other clients and meetings. Also, don't risk offending your lawyer by asking them untoward questions about their qualifications and professional competency. For example, where they got their law degree, how long they've been practicing, and how many times they've worked on a file like yours. If you want to know the answers to these questions without asking the lawyer directly, you can often find this information online or by asking the lawyer's assistant. Also, don't talk over your lawyer during meetings and prevent them from speaking. If you're hiring a lawyer, you probably value what they know and what they have to say. If you spend too much time talking, you'll simply be conveying information that you already know and not learning anything new yourself or getting any value. At the beginning of any discussion with a lawyer, let them start the talking. Lawyers are trained to seek information in a specific way. To have the most effective meeting possible, you don't want to disrupt them and their system. If you find that after speaking with a lawyer there's information that you have that they didn't ask for, then give them that information. Unless, of course, it would have made sense to interrupt them earlier and provide it at that time. I've had many clients who talk far too much and provide irrelevant, unhelpful information. Don't do that. Finally, if you're contacting a lawyer for someone else, note that the lawyer will eventually want to speak with that person. If you were calling a lawyer to get help for your son who was terminated from a job, there's nothing wrong with that. But the lawyer would eventually need to speak directly with your son because he's the one that was terminated from the job and he's the one who will ultimately be the client. On a related note, sometimes people hire a lawyer, but then they have someone else do all of the talking for them. If you were a business owner and you hired a lawyer to help you with your parents' estate, but you eventually requested that your lawyer communicate with you through your assistant, you'll eventually need to speak with the lawyer yourself because they'll need to be able to be satisfied that the communications and instructions are actually coming from you, the client, not an intermediary. At the heart of all of these finer points is the same rule. Keeping your lawyer happy and maintaining a respectful working relationship is a great way to get the best results out of hiring a lawyer. So there you have it. Those are my 5 rules for how to get the best results when hiring a lawyer. If you learned something new from this video, then make sure to subscribe to my channel right now. Just click the subscribe button below this video. And now I'd like to turn it over to you. Which one of the 5 tips in this video do you think is the most important for getting the best results when hiring a lawyer? Let me know by leaving a comment below right now. To download my template for getting all of your information together in one place, please visit my website, www.seandillman.com. Thanks again for watching. I'm Sean Dillman.